connection with the students, and it feels good to, to, to get wished personally like this. Anyways, meeting after a gap of almost 2 months. We did not meet in August, and so it's 2 months now almost that we met. Uh, Nevertheless, I'm sure some of you all would have gone back to the recording. Some of you all would have gone back to the notes that we have been doing so far and all, and trying to remain current with the topic. And also, you all would have progressed a lot with the other subjects now. So there's a possibility that you have. There was a mention of some of the things that we have done over here in some of your other subjects also, because everything is interrelated. So sometimes you get to hear um, things which are relevant to one subject also in another subject. So perhaps you would have got an opportunity to learn that, ponder over certain things that we have spoken about in our earlier classes and also. We have done 2 classes. We have that is the Indian Contract Act, and if I am not mistaken, we have completed indemnity, because that's what I have mentioned in my notes. And we would be doing the remaining special contracts today, that is guarantee, bailment, and yes, let's be ready for the class. Yes, also contracts. Let me again make uh, our contracts which have certain special features from the other prerequisites normal contract. I would reiterate that a contract is a valid, have a proposal, it should be with, there has to be and legality of all this would hold good also for a special contract. Special contract things in primarily necessary, the core of any contract. Contracts would have one special feature, like is about uh, another party who would say that you are going through a loss. Is everybody able to hear the faculty properly? Is the question.
Yes, we are able to hear.
Yes, we are
Able to hear, no?
Yeah.
Okay, sorry. Irfan, anything?
Yes, madam. Yeah, because there's some fluctuation in sound in between. That's why I just asked the student whether they are able to properly listen the lecture. Otherwise, in between, it is difficult to interrupt the lecture.
Could it be from your? Yeah. Could it be from your side then, or you think it's from my side only?
The network fluctuation is showing on your screen as your network is getting slow and high, slower and high.
There's a possibility because there is a problem with my Wi-Fi in a past couple of days.
Okay, and if as far as the students are okay with that, then it's fine. Thank you.
Okay, thank you. I'll continue then. Okay, so I was speaking about indemnity, and indemnity we said a special feature of indemnity is loss. Only when a loss occurs, actually, this contract of indemnity comes into play. Okay, so for instance, we speak about a contract of insurance. What is a contract of insurance? If somebody a mediclaim or car accident, car insurance, general insurance, that is what happens is if the car if there's any damage done to the car, Okay, that is the time when the contract of your insurance will come into play. That is only if there is a damage to the car, then the insurance company will be able to pay you that the amount that they have assured to you that they would pay in case of that kind of a damage to the car. Correct. So likewise, all other special contracts would also have some specific feature that would, make that a contract, and only these contracts would only be validated, or they would only become active, not validated. Sorry, that was the wrong word. These contracts would only become active when there's a flaw in one of those, in any of those special features that contracts are made for. When we are going to speak about those contracts, you will understand exactly what I'm talking. I'm sure you all have understood indemnity quite well now, because indemnity is something that is extremely important also in your, from the shipping perspective, even if it comes under commercial law. Why are we studying these commercial law? Because shipping is a commercial activity by itself, correct? So in order to understand shipping and the activities related to shipping, commercial activities related to shipping, we need to understand what are certain do's, don'ts, or what are some certain privileges, certain immunities that people can get, immunities that people can get in case if these kind of laws are there, or in case if people have to, I'm not saying commit fault, but if somebody has done an action which would injure the shipping company also, what are some of the remedies that are available, and all. So these are the things that are important in the commercial law to understand. And that's the reason why, and when we were doing our when I was speaking about the content or the syllabus in the first topic itself, I had said that if you, even if you look at your look at the syllabus, if you look at the book, commercial law has a big chunk of content in the syllabus. Okay, so we are still, it's the third lecture now. Today also, most of the lecture we are going to spend on, not most, whole of the lecture we are going to spend on commercial law. And if need be, because there's also another topic after we complete the special contracts, that's the Sale of Goods Act, which also I don't think we will be able to cover it today. So we will be covering it in the next class. That's the fourth class. So, but that's how your commercial law is important in your entire syllabus. And like I said again and again, shipping is a commercial activity. Therefore, all these acts, all these things, all these contents that we are speaking about, all these concepts that we are speaking about, they hold good for your shipping law also. So for instance, indemnity, when we are speaking about indemnity, what happens in shipping, particularly what is shipping? Basically, it is about transporting either your cargo or human beings from one port to another. That is the major activity of shipping, correct? So it is doing some kind of a commercial transaction in that sense. And while speaking about cargo, if you're speaking about cargo, what happens is somebody is giving the shipping agent the cargo, then that cargo is getting, that is goods, or your containers, whatever you want to call them, name them. And then these containers are then they go into the ship, and then the containers are transported to another port. Over there's a consignee who comes and picks up the goods uh, from the port. That now the goods have been passed through so many hands, okay, and each of them need indemnity that the goods are not dangerous in nature, or each of them will need indemnity that the goods are transported in appropriate manner from one hand to another hand, from another hand to another hand. So because if there can be a loss, correct, while from one place to another and to another, from one hand to another, there's a possibility that goods can get damaged, goods can get lost. So for all of this, the consigner and the consignee will be at loss if the goods are damaged, lost, or semi-damaged or whatever. So for that, they will need indemnity. Also, if the goods are of hazardous nature, and if it is going to cause any kind of danger to the entire cargo, to the entire vessel, then the ship owner, the agent, all of them would also need indemnity from the consignor who is actually loading, wanting to load or send the goods or transport the goods, correct? So that way, the way indemnity is also important in your in the shipping contract. In the same way, we would also be seeing about who are working in the shipping, give better examples of how gap given in shipping contracts. What are the different that are those are there or who are on the forefront. We are going to speak about bailment, that is hypothetical. We're going to speak about all that. Now things have changed. So inshallah, that we're going to speak about all of this in detail now. All of this. I am already exhausted, but I'm sure you are not exhausted and you are interested in knowing how these contracts would be useful in the shipping industry, because you're the one who are going to manage the shipping industry. You all are the one who are the future of the shipping industry, and you should be knowing these things well. Okay. So with this, I will now stop showing you all my face and I will share the screen with you so that you can see the contents of the contract and contents of the syllabus, and we'll take it forward from there.
Ma'am, your voice is not coming.
My voice is not coming?
No, it's audible to me. I can hear you.
Yeah, ma'am, your voice is audible.
Thank you so much. I mean, I'm now what is going to now all the entire 3 hours I'm going to be conscious about whether y'all can hear me or not hear me. Now this is going to happen. But anyways, at any point of time, if anybody feels that my voice is not clear, please put it in on the chat. If we see that there are majority of people who cannot hear, then let me see. One will have to help me, in fact, with what we can do with the connection. But I think so far so good. If majority of you all can hear the lecture, I think I don't have to worry, because nothing is showing from my end. From my end, it is showing me that the connection is fine and perfect. Okay, so fill in my presentation. Can you all see my presentation?
Yes, ma'am.
Yes, madam. Can see the slide.
Yes.
Commercial and shipping of first year.
Yes. Thank you so much. Okay, we will. This is something that we have already done till here, and now we have to start from. 1 minute. I am again a bit. Irfan, do I have a whiteboard on the screen? On this?
Yes, of course. Yes, you have. When you click on the share screen, the third option, the second option is whiteboard.
No, I can't see that. Let me see advanced sharing options. No, I can't see. That's what I was wondering, where is the whiteboard?
You're using MacBook.
Yes. Yes.
Maybe the option somewhere else, but it is there. The moment you click on the share screen, it will show you 2-3 options as if
Yeah, it is showing me one participant can share at a time, multiple participants can share simultaneously, and advanced options, but I cannot see.
no, not over there. You're clicking on the side arrow. Don't click on the side arrow. Click on the
Okay,
main
I
tab.
got it. I got
Yes,
it.
yes,
I
yes.
got it. Yes, I got it. Thank you so much.
Okay.
I got it. Okay, so uh, I don't know if you all can see my screen now, or you all can see the whiteboard.
Yes, yes, we can see, ma'am.
The whiteboard. Okay.
Whiteboard.
Okay. Okay. So as and when I feel I should write something, I will write on that. So now we're going to speak about guarantee. And okay, text. Do I have an option of typing? Yeah. So we are going to speak about the contract of guarantee now. Okay. And when we speak about the contract of guarantee, first and foremost, we have to understand why for what this contract is in place at the first place. You know, when we speak about guarantee, there are 2 or 3 things that come to our mind. One is guarantee of the product, you know, that the product is in best quality, good quality, and all of that. That is one part, you know, that we speak about when we speak about guarantee, giving a guarantee about, you know, some goods and services that we speak about. The second thing is giving a guarantee about a particular person or an act of a particular person. So here, what we are going to speak about is basically giving a guarantee for an act of a particular person. Some of you all would have taken housing loans, or some of you all would have seen your parents taking housing loan, or, you know, sometimes even any other type of loan, not necessarily only housing loan, but even some other type of loan, maybe a car loan, a vehicle loan, or maybe any other kind of loan for which, you know, you wanted to start your business or something like that. Okay? Now, when you have taken this loan, what happens typically is that you have borrowed money. You have borrowed money either from the bank, or you have borrowed money either from somebody personal. Okay, and when you're borrowing money from someone, uh, and that someone is lending you money, may it be a financial institution, or maybe these are just some examples that I'm throwing across. Okay, may it be a financial institution, or may it be, you know, someone personal, or may it be anybody who is lending you this money. Somebody who's lending you the money would need some sort of guarantee that that money is returned back. Correct. Even if you're lending money to someone, you would, and if it is in, you know, in few lakhs or few crores, you know, you would want somebody who would guarantee you that, you know, this money would come back to you, okay, on time, with proper interest, and all of those things that are there. Okay. So in this kind of a contract, you know, when you are lending money, or somebody is lending money to you and you're borrowing money from someone, this lender would ask for a guarantee from you. Okay. Now, guarantee could be in two types. So they would ask you to mortgage or hypothecate certain property with them. So that's a different story. We'll be speaking about hypothecation or pledge or all of that as a separate topic altogether. Okay. But what we are going to speak about today is a person giving guarantee for, you know, a person who has borrowed money from the lender. Okay, so there would be some individual, or some group, or a group of individuals who would tell the lender that, do not worry, if this person is not able to pay back the money, we will stand as a, you know, we are standing as a guarantee. If he is not able to pay money, we will pay you that money, and yes, we will sort out amongst ourselves. Me and the person who's borrowed money from you will sort out amongst ourselves later on what needs to be done. But if he is not able to pay you the money, then I will pay you the money. Okay. So now in this contract, how many people have you seen, or how many parties have you seen? There are 3 parties basically. So the first party is the person who's borrowing the money. It all starts from there. As principal debtor. And third is the person who is guaranteeing that this money will come to him. So this person who is guaranteeing is giving a surety, is assuring the creditor that your money will come back, correct? Assuring the creditor, and from that word has the word come. He is the surety who is telling the creditor that if the principal debtor is not able, okay, so now if you see here, it is a contract which has three parties to it. Okay, but now when we speak about this contract which has three parties to it, what happens is there is a contract between, it is not a three, it's not a single contract with three parties in it. Okay? It is a contract which has three separate agreements. So there is an agreement between the principal debtor and the creditor for lending and borrowing of the money. Okay, there is an agreement between the creditor and the surety, where the surety is telling the creditor that if the principal debtor does not pay you, I will make the payment. Okay, so that is the second contract. So this is the first contract here somewhere is the second contract between these two. And then made to the creditor. It is not that the surety is doing any charity, correct? The surety, if the surety is paying the creditor on behalf of the principal debtor because they defaulted, then it is the duty to pay the surety that point. So there is this third contract between the principal debtor and the surety. Okay, so like this, there are three contracts. So the first contract is a contract between the principal debtor and the creditor, which is a simple contract. Any other contract, it may not just. But if you look at the contract between the creditor and the surety and the creditor, these are basically contracts of indemnity. Indemnity. Why are they contracts of indemnity? Because if the creditor is going to suffer loss, if the principal debtor will not pay the creditor, what happens? The creditor will suffer loss, correct? If the creditor suffer loss, then the contract that the creditor and the surety will enter into will be the contract of indemnity, where the surety is indemnifying the creditor that if you suffer loss, I will make your loss good. Correct. And likewise, there is a contract of indemnity between the principal debtor and the surety that if the surety is making that payment to the creditor, then what happens is the principal debtor, so the surety has now suffered loss. He is unnecessarily paying. Hindi mein jo bolte hai, khaya na piya, glass thoda, barana, whatever. That type of situation that surety will fall into, correct? He has not got any benefits out of this. But now what is happening is he is already paid. So he suffered the loss. So it is now the time of the principal debtor to assure the surety that he will make the loss good. Okay. Now the contract between the principal debtor and the surety is always an implied contract. Most of the time, I'm not saying always. Always may be a wrong word to use. It is an implied contract. That is, it may not be in written. Okay, the principal debtor, there would not be a written contract between the principal debtor and the surety saying that, okay, boss, if you pay on my behalf to the creditor, then I will, pay you back and all. It will not be in writing. It is implied. What is in writing may be a contract between the principal debtor and the creditor, and the creditor and the surety. Those contract may be expressed contract where it is if not in words, it is if not in written, it is at least in words orally that yes, I am giving you the money, and okay, you please give him the money. I will make your loss good if he is not able to pay the money. Question that is there. Okay. But contract between principal debtor and surety may not be an express contract. If the surety is making payment on behalf of the creditor, then it is the principal debtor's right, liability or duty to. Okay, I hope. So now what happens? The next. I thought, let us cover some of the theory three front of us so that it will become we are talking about. Okay. Now, okay, principal debtor has borrowed. Okay, creditor has given principal debtor the money. The debtor the money. Paid back the money. What happens to the role of the surety? The surety's role doesn't come into existence only. That agreement doesn't come only into existence because the contract is already fulfilled between the principal debtor and the creditor. Like I said, the contract between the creditor and the surety is the contract of indemnity, and therefore that will only come in there is a loss that. So in that talking about principal debtor paying the money to the creditor, the contract is closed. Therefore, the contract that the surety and the creditor had entered into, that has also been revoked or terminated. That into picture only. Or the principal debtor and the surety, that contract also is a necessity to bring it into picture. Correct. But let us look at the other scenario in which the creditor has given money to the principal debtor, but the principal debtor is not able to pay back the creditor. What happens is the contract between the creditor and the surety becomes activated.
Excuse
that
me,
gets
ma'am.
activated.
Ma'am, I have a question. If in the principal debtor is able to pay the creditor, then the surety role goes away completely. Then what is the profit of the surety then?
Why would there be a profit of the surety? The surety is not playing any role to gain any profit. The surety is only here in this entire transaction to support the creditor and to support the principal debtor in case if the principal debtor is not able to pay the money. If you're taking a loan from the bank, it is or your stand a surety for profit and surety for goodwill. They help you. So any question of any profit that a surety.
No,
Okay,
ma'am,
I thought
questions, there might be business doing these kind of business where not sure, we are not into this because of that.
I don't think that is the scenario in this case. It's not doing business over here. The surety is only there. So keep that in mind perfectly well, that this is not sure. The surety is only and only there to support the principal debtor and the creditor. Okay, so there is no question of any profits happening over here. Okay, so let me continue with what I was saying. So in the second scenario, we are saying that the principal debtor has not paid the money to the creditor. Agreement between the.
Ma'am, I have a question.
Yes.
Just see, I mean, the principal debtor will not pay the money to creditor. Then surety comes into, I mean, activated that he'll pay the money in behalf of principal debtor. And later on, the principal debtor doesn't pay to surety. Then what will be happen?
We have not yet come to that stage. So let us let us first talk about, what happens in this scenario. When we come to that stage, if your question is not answered, then we will, then you please point this out to me. Because we are at the initial stage itself, we are just doing the ABC, and if you want to know the answers of XYZ, then it will become difficult to take the conversation.
No issues.
Yes.
Ma'am, only one small question.
So
This
hold
surety is an individual person, right? Because he's not making any profit kind of thing. Is it an individual person or it is like a financial institution, like a creditor? Or
most
something?
of the times it is an individual person. It could be a financial institution also, if a financial institution wants to stand a guarantee to someone, but most of the times it is an individual person, or it is a group of people, actually one person, or more than one person. It could be a single person, or it could be a group of people. It
So
is, yeah,
it's
seldom,
likely a pool of money will be coming together and
yes.
okay, ma'am.
Pool of money will come together only if the principal debtor has defaulted. If the principal debtor does not default, the agreement between the creditor and the surety will never be activated. So then there will be the surety will be discharged of his liabilities, whatever they have entered into a contract, whatever contract was there between the creditor and the surety, that entire contract will be cancelled. It will be terminated. Okay, so the pool of money, or whatever you're talking about, will come into picture only if the principal debtor has defaulted in the payment. So
Okay,
if the
ma'am.
principal debtor defaults to pay the creditor, then the creditor, then yes, that is the time now when the creditor and the surety, the contract will become activated, and now the surety, it will be the time of for the surety to make the payment to the creditor, as it was mentioned in the agreement between the creditor and the surety. Now what happens is, in this case, the surety steps into the shoes of the principal debtor, and whatever the principal debtor was liable to do, whatever the principal debtor was liable to pay, all that the surety will do. Okay, for the time being, the principal debtor will be out of the scenario, and the surety will take the position of the principal debtor. Okay, and when the surety will step into the shoes of the principal debtor, then, like I said, whatever the principal debtor would have done in his capacity as a principal debtor, that is something that the surety will do. So whatever principal amount he had to pay, he will have to pay that. Whatever interest he had to pay, he will have to pay that. Whatever, even if there was any penalty clause that was there and any penalty had to be paid, the surety will have to pay all of that. Now he will have the right to recover everything from the principal debtor. That's a different story. But for the time being, only understand that the surety will stand in the shoes of the principal debtor. Now, how he is going to make this profit, as you all were speaking about, from the principal debtor, that is completely a different story, which will be addressed later on once the surety has made all the payments or cleared all the liabilities of the principal debtor. Okay. Now, the surety there cannot be any conditional clauses that the surety will put. The surety will straight stand in the shoes of the principal debtor and will have to pay everything that the principal debtor would have done to the creditors. Okay, so that way the surety will pay the entire amount. Now, in case if the surety, I'm sure that would be the next question that would come up. What happens if the surety doesn't pay? If the surety doesn't pay, then the creditor will have all the right to file a suit for injunction, file a suit for damages, file a suit for the principal amount that was paid, file a suit for the interest on the amount, and both. He could do that with the first party being the principal debtor, and also the surety as the second party. He could file a case, file a suit against all these people. But that's the next thing that is happening. Why should we, in the beginning itself, think about the surety won't pay? So let us look at.
And I'm also for the litigation charges, right?
Yeah, everything. If you have attended the lecture of contract, we have seen the remedies for contract. All those remedies of contract will hold good in this case also. Okay. So yes, all those remedies will the creditor will get the benefit of all those uh, remedies that were available. And the same will happen then later on. So now this contract is done, the surety has paid the creditor, and so the contract over here, the contract between the debtor and the creditor is also revoked, or it is terminated, and the contract between the creditor and the surety is also terminated, because the entire deal is done. Now only the contract between the principal debtor and the surety will still remain, uh, because it is the liability of the debtor to make the surety's loss good. Now the surety has suffered loss. Okay, when the creditor was suffering loss, the surety made his loss good by paying all the amount. Now the surety has suffered loss. So who's going to make his loss good? His loss is going to be made good by the principal debtor. And like I said, even if it is most of the time it is an implied contract where there is nothing in writing, where there's nothing said, but yet it is the right of the surety, and it's the liability of the principal debtor to pay all the amounts, and there could be also interest on the amount that the surety has paid the creditor, which he can uh, um, uh, make the principal debtor pay him. Okay. Now, if the principal debtor doesn't pay him, then again he will have remedies of going to the court, suing the principal debtor, and all those remedies that we saw in the law of contract would also hold good for this particular transaction. Okay. So this is typically the contract of guarantee. Let us go further into the slides now and see more about the guarantee. What is the definition? What are the what are the features of guarantee? What are the rights of the surety, and all of that. Okay. So a contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. Okay? Liability of a discharge the liability of a third person. So who is this third person? It is the principal debtor, who's the third person, if his liability has to be fulfilled in case of his default. The person who gives the guarantee is called the surety. The person in respect of whose default the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. Okay, a guarantee may be either oral or written. It can be in any form. Not necessarily that a guarantee has to be in written only. It could be an oral guarantee also. But what happens is, typically when the amount is of the value of this entire contract is huge, then in those scenario it is always better to have something in writing, because written contracts or written agreements are easy as it can be shown as evidence easily, whereas for oral contracts it becomes difficult to prove it. And in this case, in the case between the creditor and the surety, it would become the creditor's duty to prove that the surety had assured that he would make the loss good, or he would pay for the he would discharge the liability of the principal debtor. So it's always better to have something in writing, no matter how big or small the amounts are. But the law doesn't force that the contract of guarantee has to be in written only. So if there is no contract in written, it doesn't mean that the parties cannot file a litigation in the court or sue one another in the court just because it was an oral contract. Okay, so that's the reason why this line is very important, that the guarantee may be either oral or written. Let us look at the essentials of a contract of guarantee. So there are three parties that we have already seen. There's a principal debtor, there is a creditor, and there's a surety. Okay, three parties, three contracts. Like I said, it is not one contract in which everybody will, will be a party, but there are three different contracts. Okay, of course, there's a consideration for the consideration which the principal debtor was supposed to be paying to the creditor, and if that consideration is not paid to the creditor, then the surety will pay that consideration to the creditor. For this purpose, actually, this contract is in place. Okay, there's a primary liability and there's a secondary liability. So the primary liability to pay the money is principal debtors. It's the principal debtor's primary liability to pay the creditor, and it is the secondary liability of the surety to pay the creditor. Okay. All the three parties have to agree to it. It is not that the principal debtor will say that I want this person to stand as a surety. The creditor may say that no, we don't want this person to stand as a surety because we do not see that he has a net worth of what you would be able to, of what he would be able to pay in case if you default. So the creditor may say that we do not accept this person as a surety, or the surety may say that I do not want to stand a surety. Okay. So when we are speaking about a contract of guarantee, all the three parties, that is the principal debtor, the creditor, and the surety, should agree and accept that this particular person will be a surety in this entire contract. Surety is distinct promise. It's a promise of the surety, which really plays an important role in this entire contract to make the loss good of the creditor or to discharge the liability and promise of the principal debtor. Okay, and yes. Last, the enforceability, that is all the essential of the law of contract should be there. Only then will this agreement be enforceable. That is, there has to be a proper proposal, acceptance, all that is there. But mainly over here, when we speak about enforceability, it should be with free consent. That is really important. And the parties should be competent to contract. That is really important. And these are the essentials of the contract of guarantee.
Ma'am, what is the meaning of liability primary and secondary?
I didn't get you.
Ma'am, what is the meaning of?
Yeah, primary and secondary. No, it is the primary liability of the debtor. He is the main who's supposed to be actually making the payment, correct? So it is his primary liability. If he doesn't pay, then the secondary liability is of the surety. If he doesn't pay, then the secondary, the surety doesn't have to, it is not that at the first instance itself, the creditor will come and ask money from the surety. The creditor will first go to the principal debtor to ask for the payment. And if the principal debtor defaults, doesn't pay, then it becomes the liability of the surety.
Ma'am, I got one more doubt. Now, say the financial institution is giving a loan to the to the company. Okay, now they were not able to repay. So the surety guy is coming into picture and he is repaying the total amount. Now, if the vessel is an asset to the company, is it?
Asset to which company?
Company who owns the vessel, the company who owns the ship.
Yeah, the company who owns the ship, the vessel would be the asset. So how does it come into this?
So what I was asking is, now there is a company who's asking for a loan, and the financial institution is giving a loan for X amount of value.
For what? For what is the?
For the ship, to buy a ship, to buy a vessel.
Okay.
Maybe say $70-80 million. Now, they were unable to pay the loan within that time period, maybe say 6-7 years. They were not able to pay. Now surety is coming into picture. They are paying all the loan amount to the financial institution. Now basically on paper there is no relation between the creditor and the ship owner, is it?
How can there be no
because all the
creditor and the ship owner is taking money or loan from the financial institution. So therefore, there is definitely a relationship between the two of them, correct? How would there not be a relationship between the two of them?
But now since the money is already paid back to the financial institution.
Who has paid back the money?
The surety.
You're saying has paid back the money.
Yeah.
So the surety will have all the rights that the principal debtor has. Now, automatically, until the principal debtor will pay the money to the surety will have the right to claim. If the surety, of course, the surety will have to wait for the principal debtor to pay back the money to the surety. But if the principal debtor doesn't pay back the money to the surety, then the ship will the surety will claim the ship, the ownership of the ship. Then after a period of time, if he sees that the money is not being paid by the principal debtor.
Ma'am, but his question was that if he's not paying on time, so if he's not paying on time, then penalty comes into picture. This creditor, that person who is guarantor, that comes into picture. If he says that I am bankrupt and I can't return the money, then that is a case when guarantor comes into picture, right, ma'am? That is what is my understanding. And this relate payment will be related to penalties.
Have you got your answer? Who was asking the question? I can't see the screen.
Yeah, I got the
Have you got the
answer.
answer?
Yeah. So
Yeah.
basically, until and unless the company pays the money to the surety guy, we cannot sell the vessel to any other person.
No.
That was my question. Okay. Yeah. Thank you, ma'am.
Okay. So the kind of guarantees on basis of time and on basis of transaction. There are two bases in which the kind of guarantees are actually bifurcated. Okay. So the first is for the existing. Now sometimes what happens is guarantee is for a transaction that is in existence. Okay. And guarantee also be for a future debt. That is, there are a series of things that happen, series of debts, that is something that a person has been taking, and there's a surety who has assured that he will stand as a surety for these series of things. So for instance, look at any consumables that have been even in your shipping business. You can look at if there is a sort of a cargo that is going, so there would be a party who is sending cargo regularly by that particular ship. Okay, so there would be somebody who is standing as a guarantee for the first time the cargo is sent, and he would be standing guarantee subsequently for other what do you call that, voyages also. Okay, so there would be a guarantee that is there for the existing debt, and there would be a guarantee that is there for the future debt also. To give you a very, very simple example, A is buying goods from B. Okay, and A is buying goods from B on a regular basis, and he is buying goods on credit, and the goods are worth some lakhs of rupees, and therefore when B is selling the goods to A, he wants somebody to stand as a surety or as a guarantee, so that the payments are made. In case if A is not able to make the payments, then this guarantee will make the payment. Okay. Now, for whatever debt that has already taken place, or whatever goods that have already been sold, okay, A has bought the goods. Imagine A has bought 100 tons of goods from B, and A has to still pay the money to B, but he's not paid. So there's a surety that is there in the picture. Now, if A doesn't pay the surety, will have to pay the money. But this is for your for the debt that is there in existence. You can see it has already happened. Okay, but A is also or C rather is also going to stand as a surety to B in case if A is going to buy goods from B in the future. Okay, that would be your prospective guarantees. Guarantees become or it's not become active, but which will become active in course of time. In due course of time, that will become active, and for those, so the also see that is the surety in this example will stand as a guarantee. So when we are speaking about guarantee could a future debt. Somebody would want it to stand as a guarantee for future debts between the principal debtor and the creditor also. That is one two types of guarantees on the basis of time. And then there is again basis of transaction, that is a single debt. The same thing that I spoke about, single debt, just one time. A is buying goods from B one time, and C is standing as a guarantee over there, assuring if A is not able to pay money to B, then C is paying the money, and the entire transaction is over there. Or it would be for series of transactions where A and B are into regular business, and C is standing as a guarantee for for all the transactions that are going to happen even in the future, and that is known as a continuing guarantee. Okay, so this is, I think, very simple. Yes, the most important parts will come now. That is discharge of the surety from liability when the surety will be discharged from his liability. You know, because like I said, there was a misconception in the minds of few of y'all that why would a surety be a surety if he is not having any profit or something like that. To reiterate what I said earlier, surety is not in the business of making profit. Okay, he can perhaps try to get some interest on what loss is made good from the principal debtor. That could be a separate transaction that happens, but from the creditor, he is not. He's not going to get anything. For a creditor, he becomes a principal debtor, and he will be liable to pay, repay the liability that the principal debtor would have otherwise become liable to pay. Okay, so there is no sort of consideration that surety is going to get, and that's the reason why surety is standing as a guarantee in this entire transaction or something like that. Okay, so let us be very clear about that. Just give me 1 minute, okay? Yes, okay, sorry. So now let us speak about discharge of surety from liability. Discharge is when will the surety become free from the liability? That is, when will he become free from this contract of suretyship? Or when is it that the creditor will say that, okay, you do not have any liability further? Let us look at that. Okay, there are three ways in which the surety will be discharged from his liabilities, and then in those three ways there are again some things that have been mentioned over here. The first is by revocation, that is cancellation of contract. Why would there be revocation, or why would there be a cancellation of contract, or how would there be a cancellation of contract? Okay, uh, so if the surety gives a notice that he would like to be discharged from the suretyship, then there would be, of course, the creditor will consider the notice, and all that will happen. Perhaps there would he may not even want to consider, and then he would be the creditor would debtor would have to bring in another surety in place of this particular surety, and if the principal the creditor is satisfied that yes, this other person would stand as a surety in place of this particular person who was there. So if A is a principal debtor and B is the creditor and C is the surety, C can give a notice and say that I would not want to stand as a surety any further. And typically this happens in case of continuous guarantee, not in case of a single guarantee. In case of a single guarantee, single transaction, sorry, revocation by notice will not happen. Revocation by notice will happen only in case if there is continuous guarantee where there are a series of things happening. So in that situation, the surety can tell the principal debtor and the creditor by giving a notice and say that I would not like to stand as a surety for further transactions, so please discharge me. And the surety will be discharged for further transactions, not something that is into existence at that particular point of time. So that is can be discharged. Okay, it can be revoked. His liability can be revoked, or the contract between them can be revoked. The second way of revocation or cancellation of this contract of guarantee would be by the death of the surety. If the surety dies, then of course he would be discharged from the liability. And innovation, that is in case if the principal debtor and the creditor introduce some new clause to the agreement, and that clause is not the surety or that clause has not been, or the assent of the surety has not been taken before introducing this new clause, then the surety will have the right to be discharged from this kind of a transaction. Okay. The second way of discharging the surety is by conduct of the creditor. Okay, what the creditor does. If the creditor brings, again, same, we spoke about innovation, that is introducing anything in the transaction, in the contract. Over here also by variance is also, it means the same thing. If the creditor will want to introduce, change some terms and conditions, would say that, I would want interest of not 12%, but 14% or 15% or anything of that, or I want the payment to be made not in 6 months of variances. Also, if the creditor says that, we can for, if it was for 6 months, we can make it for 8 months, 9 months, and the surety doesn't want it to, stand for that long period, then by that the surety can discharge, surety's liability can be discharged by release or discharge of principal debtor. If the creditor says that, yes, I have nothing against the, I mean, there's no liability now from the principal, or discharging the principal debtor, then automatically also be discharged. Okay. In terms of composition, extension, or time promise, not to be sued, in all these cases, that actually comes under the clause of variance itself. Okay, composition is reducing so composition is actually when the creditor is willing to accept less amount from the principal, whatever amount he's willing to pay, and the creditor is willing to accept that amount, then the surety will be discharged. Extension of time, if, like I said, if the creditor is saying that the principal debtor, it was for 6 months, but now he's willing to wait for 9 months, 12 months, and the surety will not want to stand as a surety for such a long period, then the surety's liability can be discharged. And if there is a promise that the creditor is making to the principal debtor that he's not going to sue the principal debtor, even if the principal debtor is not paying him the money, then the surety will play no role actually. And that is how the surety's liability will be discharged. Okay. And by impairing surety's remedies, that is by weakening, it is discharge of surety by creditors, act of omission, impairing surety's eventual remedies. That is, if the creditor also agrees that, the surety does not really need to pay on behalf of the principal debtor, or the principal or the creditor says that, if the principal debtor is going to pay me less amount, or not in time, then I am going to, and if the surety is going to make the pay the money to me, I will want to charge more interest on it, or something like that. These are just examples. Then in all these cases where basically what was not there in the contract earlier, and that has now been put into the contract. Okay, in that kind of a scenario, the surety will have the right to put his hands up and say that I would not want to be a guarantee to this particular contract, because these were not the terms and conditions that I had agreed. I had agreed to certain terms and conditions, and if those are not going to be fulfilled, then I will not be interested in continuing with this particular contract. Okay? And if the contract is obtained by misrepresentation, or if it is, we have spoken about misrepresentation when we did free consent in death. In a lot of depth, we have spoken about misrepresentation, where it is not fraud, but it is there is a misjudgment, or wrong statement is made, wrong facts are given and they're given by mistake. They're not given in order to cheat someone, but they're given by mistake. Okay. So if guarantee is obtained by misrepresentation, by giving wrong facts to the surety, discharge himself from the liability. If the guarantee is obtained by giving any, by concealing any facts or not sharing the facts. Now, not sharing the facts, guarantee is obtained by fraud. So if guarantee is obtained by fraud, in both these cases, the surety will be eligible to discharge himself from the liability that he was supposed to bear for the principal debtor. Okay. And if in the contract it was said that there would be a co-surety who would also be joining, the surety alone would not be able to make all the loss good of what the principal debtor was supposed to be paying. So if the principal debtor was supposed to pay to the creditor 10 lakhs of rupees, and the surety says that I can stand surety only for about say 6 lakhs of rupees or 7 lakhs of rupees, but beyond that is not my capacity. And if somebody has to join as a co-surety, and there would be another person who would be joining, and both would be sharing the responsibility. But if that other co-surety does not join into the contract, then this surety willing to join into the contract will have the right to discharge himself from the liability. Okay, so it is not that the surety, once a surety, always a surety. It is not something like that. The surety will have the right to discharge himself from the liability. So even if the surety has joined as a surety for one transaction, does not mean that he will have to stay a surety for all the transaction. He can discharge himself from that liability if he feels anywhere that it is not a fair transaction that is happening. There's a lot of sort of you know concealment of fact, or a lot of sort of cheating that is happening. Then in that scenario also, the surety will have all the right to discharge himself from the liability. So these are some of the things that we need to know, and how the surety, how he would be able to put his hands up and say that now he is no longer liable to pay the debt that the principal debtor would have to pay. In that case, now the next question would be, then who would stand as a surety? The principal, the process of finding the surety and taking an approval from the creditor will again start, and then there would be another person or a new person who will stand as a surety, and then the contract of guarantee will go further. But of course, where the creditor has discharged the principal debtor from due to a certain this thing, he doesn't want to promise, he's willing to accept less amount, he's willing he doesn't want to sue, or if he's willing to accept less amount, or if he's willing to completely discharge the principal debtor, in that case there is no necessity for having another surety in place. Then only the discharge will happen, and the contract will stand terminated between the surety and the principal, and the creditor. And of course also the contract between the surety and the principal debtor, which would have been an implied contract, that would also stand terminated. Yes. The rights of the surety. The surety will have rights against both the principal debtors and the creditors. Because why principal debtors and the creditors? Because the surety is basically into an agreement with both the parties. The surety is into an implied agreement with the principal debtor. Of course, it could be an expressed agreement also. I'm not saying that it cannot be an expressed agreement. Maybe there's an agreement between the surety and the principal debtor saying that in written or orally that yes, if you pay the money, I will pay you back the money. But even if it is not mentioned, even if it is not expressed, it is implied that he will have to pay the money. And yes, there is an obvious contract between the creditor and the surety, and therefore the creditor, the surety will have the right against the creditor also. Okay, so what are these rights against the principal debtor and the creditor? We have mentioned some of them when initially when we were on the whiteboard and we were doing a general sort of discussion on guarantee. And yes, third right is also against the co-sureties. So each surety will have a right against the co-surety. Okay, so these are the three kind of rights. So right of subrogation. Subrogation basically is putting yourself in somebody else's shoes. So what is the right of subrogation? So right of subrogation is if the principal debtor is not willing to discharge his liability, and if the creditor is discharging the liability of the principal debtor, then the principal debtor will stand in the shoes of, the surety will stand in the shoes of the principal debtor now. So the principal debtor will basically, all his rights will go or get transferred to the creditor. So there was this question, somebody was asking what happens to the vessel. The vessel is bought by the principal debtor, but the principal debtor has not been able to pay the money to the creditor or the financial institution, and the surety has paid the money to the financial institution. So all the documents that the the financial institution, when you're taking loan for the vessel, you would have mortgaged, hypothecated all documents, correct? With the creditor, all the documents will go back not to the principal debtor now, they will go back to the surety. The surety will hold the rights of the ownership rights of the vessel until the principal debtor will pay the money back to the surety. Any other rights and rights that the principal debtor would have against the creditor, now all those rights will pass on to the surety unless the principal debtor will make the surety's loss good. That is the right of subrogation. This was the question that somebody had asked, correct?
Ma'am, subrogation means that to recover the all monies from this principal debtor.
Subrogation basically means to stand, to get the rights of the person of some other person. It is to get the rights automatically of some other person, stepping into the shoes of somebody else. That it means. So principal debtor has not paid the money to the creditor. He has defaulted. Correct. If he would have paid the money to the creditor, then what would have happened? He would have become the legal owner of the goods, of the vessels, of whatever he had taken loan or any financial aid. But now, because he's not paid the money, who's paid the money? The surety has paid the money. Okay. Now, if the surety has paid the money, then what happens is he will hold all the rights of the principal debtor. But of course, yes, the ownership of the ship or the ownership of the goods will not completely transfer to the surety, because there's a possibility that the principal debtor, now in these kind of transactions, typically, it's on installment basis, correct? So a lot of installments would have already been paid by the principal debtor. Okay. So for instance, if, the installments had to be paid for rupees 10 crores. Okay. And the principal debtor has already paid about 6 to 7 crores, and the surety is only paying the remaining. That is about 3 crores. And if there was a delay, then interest on those 3 crores, then the surety cannot actually get the ownership of the entire vessel. Okay. So the surety will have to wait for the principal debtor to also make the payment of about 3 crores to the and with the interest amount that the surety has paid on that 3 crores, and also maybe interest amount that the surety will want to fetch from the principal debtor. For all that, the surety will have to wait. It is not that the documents will all become on the name of the surety, but it is just that the documents will the surety will have the right to hold the documents unless the payment is made to him, because if the payment is not made, Just 1 minute. Okay? There is some work going on in the neighborhood, so sometimes it becomes a little. So, so the ownership of the vessel will not directly be transferred in the names of the surety. Of course, they will have to wait, and the surety will have the right to sue this person, the principal debtor, if he is not paying, and then he will have the right to claim the ownership of the ship for and until the remaining amount is not being paid. He will have the right perhaps to go and sell the vessel and make the loss good. And of course, then whatever amount that the principal debtor has paid for the vessel initially, that amount that the surety will have to return back to the principal debtor, because principal debtor has paid a major chunk of whatever loan that was taken. So all these things need to be taken into consideration. It is not as simple as we talk that principal debtor, that the surety will stand in the shoes of the principal debtor, and the principal and he will get all the rights that the principal debtor would have got against the creditor and all of that. But yes, there are certain things that uh, that will need to be taken into consideration. Also, what exactly has transpired in the entire transaction, what is the amount of default, how much is the principal debtor, how much was the principal debtor liable to pay, how much is the surety paid, what is the cost of the goods, and all those things will have to be taken into consideration. There was somebody who had raised their hand. If you want to ask the question, the person who had raised hand.
Yes, ma'am. This is Vikas Kumar from this side.
Yes.
And my question is in the previously we listened that the surety most of time he give the guarantee orally, not in written. Okay, ma'am. Then if in any way debitor has been not paid the amount in any manner, then it's have the right to go in a legal case because they have no written communication in the
We
oral
spoke
basis.
about that. No, we spoke about that. I think we are wasting time speaking about the same thing. Contract of guarantee can be oral or written. It will only be whoever is going to the court will have the will need to prove whether what they're talking is right or wrong. I think we have spoken about this already. There was somebody else who raised their hand. I saw somebody else raising their hand just now. If you all have any question, quickly, because see, like I always tell, I've already spoken to you all about this, and I'm telling you this again, over and over again, that these are topics which we have learned in our law college days, or which we have learned even when we were doing our sort of other lectures and all. We have taken about 13, 14, 15, 20 lectures to do this topic, and we are expected to do these in in one lecture itself. So we cannot be sitting on one particular topic, one particular thing for a very long time. If you have any doubts after the class, you can always send me a WhatsApp and clear your doubts. Also, we cannot just sit on one particular thing and keep speaking about that for very long. So about oral and written contracts, we have already spoken. So I hope if you have not heard it, you can go back to the recording later on and speak about and listen to it. Okay, so right to subrogation is basically when the principal debtor will step into the shoes of the surety will step into the shoes of the principal debtor and get the right that the principal debtor would have otherwise got. And then there is a right to indemnity. And this is what I have been speaking about continuously, that there's an implied contract, even if there's no express contract, there's an implied contract wherein if the surety is paying on behalf of the principal debtor, then the surety will have the right to be indemnified by the principal debtor, that he will make the loss good to the surety. That is, in this example that we spoke about, the vessel worth, just for instance, worth 10 crores. Loan was taken by the principal debtor from the financial institution. The financial institution, the principal debtor was able to pay the financial institution 7 crores. 3 crores he was not able to pay. He kept defaulting, and the surety's contract was then activated. The surety has paid those 3 crores. with some amount of interest for the default that has happened. So now the surety has the right to be indemnified by the principal debtor, that those 3 crores plus the interest that he has paid on those 3 crores to the creditors will be returned back from the principal debtor to the surety. Okay, so that is the right of indemnity.
Ma'am, I have a doubt. Just as you said now that principal debtor have paid the money around out of 10 crores, 7 crores has paid to the creditor, and the leftover the 3 crores been paid by the surety. In such case, like the principal debtor couldn't pay the money. I mean, like out of 10 crores, only 1 crore is paid, and the rest of the money paid by surety. So the sureties have a right to, same to be recovered from the debtor. And if he couldn't recover that, then he can be own the vessel as he has a more amount paid.
See, owning the vessel and all, that's it's something that can happen. But then if he is owning the vessel, then he will have to pay back to the principal debtor.
Principal debtor also, that whatever the 1 crore he has been paid.
What happens is, typically in all these cases, it is not just that the creditor will say, the surety will say that I will own the vessel, and the principal debtor will say yes, you happily own the vessel. All that will not happen. Okay. Typically.
No,
yes, it can happen amicably also. I'm not saying that it will not happen. If the principal debtor feels that that he is not, it is humanly impossible for him to make this payment, and amicably also they can settle amongst themselves that yes, I am willing to pay that amount. Maybe you pay me 1 crore of rupees, or whatever you wanted to pay, or that will depend upon the terms and conditions that they discuss then further, and he could transfer the ownership in the name of the surety. But it doesn't happen so easily, correct? When goods are of so many worth so many crores and all of that, it doesn't happen so easily. So the most convenient route then becomes through the court, and then it will all depend upon what is it that the court has to say. Why is it that the principal debtor is not able to pay the money? Is it that the principal debtor's company is going into liquidation? And if the principal debtor's company is going into liquidation, then is it possible that from that amount from the selling of all the assets and all that, the creditor's liability will be discharged? Or what is it? There are different scenarios. When you look at even a particular case, if you just try to look at one case law, just pick up any citation and look at one case law. So if you're looking at any one particular case law, that one particular case law will not have just one point of discussion or one particular section from one particular act that will be looked at. The case law will be looked at holistically, taking into consideration various acts, sections of those various acts, and then a particular decision will be come at. The judges will come at a decision looking at
all the aspects together
that are there. Okay, so in this case also, it is not as simple as saying that okay, the principal debtor has only paid 1 crore and now I'm going to pay 9 crores, so I become the owner. It is not as simple as that.
Okay.
That will also require formalities. If it is happening amicably, it is a different story. There would be a contract between the principal debtor and the surety then, and whatever was there in the names of the principal debtor, probably he will transfer it to the surety by paying him, not paying him, because again we don't know why the surety is a surety. The surety may be a surety for the principal debtor because maybe he also owes something to the principal debtor. Of course, that owing something will not come into picture over here in this particular transaction. Okay. This will be a transaction independent of any previous transactions that were there between the principal debtor and the surety. But all these scenarios have to be taken into consideration before actually coming to a conclusion that now the surety becomes the owner of the vessel. Okay, getting my point. So there are a lot of things. Yeah. So there are a lot of things. Yeah, you have another question you said?
Yeah, actually, like once been like the surety paid the money, as I said, as he recovered the vessel from him. So it's anyhow it's an asset, then have a depreciation. So it's being a loss for him also, no? So he may can claim a more money on
That's what I'm saying. That will entirely be the prerogative of the principal debtor and the surety to decide what they want and what they do not want. See, if you have listened to our conversation about what are the various features of a valid contract, we have said consideration is one of the features. If you look at consideration very, very carefully, it says consideration may not be enough. Okay, consideration may not be enough. That is, I'll give you a very simple example. You are taking a car from your friend. Okay, it's a second-hand car. Okay, the car is worth rupees in the market. This second-hand car perhaps worth rupees 1,50,000. Okay, but your friend is selling it to you for 50,000. Okay. Now, what is the consideration in this amount, in this transaction? The consideration is 50,000 and not 1,50,000, which is the market value price. Okay. So if you are not paying 50,000, then your friend will have the right to sue. Yeah. Your friend will not have the right, will not be able to say now that the market price is 1,50,000, so you pay me 1,50,000. What was agreed between the two of you? Consideration was 50,000. Yes. So the consideration may not be enough because the market price was 1,50,000. It may not be enough, but there was a consideration that was decided, which was a lawful, legal consideration that was decided between the two parties. Okay. And when that consideration was decided between the two parties, then it is very clear that that is the consideration that will have to be taken into consideration for the contract. Okay, so likewise over here, depreciation, no depreciation, but then because there is depreciation, the value will increase. The surety may want to not even take that 1 crore from him. Yeah. The principal debtor may not even want to take that 1 crore from him and say that, no, it is all right. I'm not able to pay. I am transferring the vessel on your name, because there could be some previous transactions that have happened between him and the surety where he was liable to pay some amount. We don't know. So all these terms and conditions will be taken into consideration when the principal debtor and the surety will then enter into a contract for this. Okay. Over here, what we need to focus in what are the rights of the surety against the principal debtor. So there are two rights. One is subrogation, in which the surety will stand in the position of the principal debtor, and whatever right the principal debtor had against the creditor now, whatever right, after the principal debtor has paid the money to the creditor, the main right is, to take back the documents that were mortgaged, to take back all the properties that were, that were mortgaged by the to the creditor. Now those will be mortgaged with the surety. Okay. So that is the right of subrogation, and the right of indemnity is what is the surety going to do? Today I am not into the shipping business, but because I have money and my friend is into the shipping business, and my friend is buying a vessel of millions of rupees, and because I have the money, I am standing as a surety. But what is going to be my benefit if if my friend is not going to pay the money? What will I do with the vessel? I am not even into that business. Perhaps I will sell the vessel and make money, but that's also not my business. What I want is, I want my money back. I want to be indemnified for that. My loss, whatever has happened, I want that loss back. Okay. So these are the two rights that the principal debtor will have against the the surety will have against the principal debtor. Subrogation and indemnity. Yes, okay, there is a hand raised.
Ma'am, but also the surety will now take a place of the creditor, and then the surety will have the right against the principal debtor as well, right?
Yes.
So the surety will have two places to be, like at the place of the principal debtor as well as at the place of the creditor. Yes. Okay.
Okay. So when so what happens is, when the surety pays the money, okay, when the surety pays the money to the creditor, then now the surety will become the creditor. That is one part. Okay. But if the surety has paid the money to the creditor, whatever rights the principal debtor had from the creditor, For that, he will stand in the position of the principal debtor.
Principal debtor.
Okay, so the principal debtor, whatever, so like I said, when you are taking money from a financial institution, what happens typically is you're mortgaging certain hypothecating certain documents, you're pledging certain documents, you're pledging maybe some ornaments, you're pledging some, properties, all that with the financial institution. Okay, now because the surety has paid the money, that will come to the surety and not go to the principal debtor, although the money has been paid. Okay, that is what I'm saying when we are speaking about a right of subrogation. But yes, he will also hold the position of the creditor, and now when he becomes the creditor, he will have the right to make his loss good. That is the right of indemnity from the principal debtor, because now he is the creditor, and whatever money the principal debtor would have paid the creditor, or whatever money the surety has paid on behalf of the principal debtor, now the principal debtor will have to pay the surety, and the surety is now the creditor. Correct? Okay. So right against the creditor, like we spoke about the right against the principal debtor. We said that whatever right the principal debtor had, so whatever things he had pledged as security with the creditor will all go to the surety now, because the surety has made the payment. Okay, so that is the same right that the surety will have against the creditor. Now the creditor cannot say that no, these securities, they belong to the debtor, principal debtor. One minute, one minute. Okay. So now the creditor will not be able to say that no, these things belong to the principal debtor and we will not give it to the surety. We will give it to the principal debtor only. No. Now the surety has stood in the shoes of the principal debtor, and hence all the rights to the securities that the creditor, that the principal debtor had pledged with the creditor, will now go to the surety. Okay, and the right to set off. So any claims, any other claims, he has paid his money. He has discharged the liability of the principal debtor. So anything. Just give me one moment. Sorry. So yes, so the first right is right to security, and the second right would be right to set off. That is when the discharge, when the payments have been made, the liability the principal liability, debtor's liability to the creditor is discharged, and the surety will also be discharged from his liability, because he is already paid to the creditor, and whatever the transaction that will be set off, and everything will be cleared off or squared off. Okay, so these are the rights against the creditors. And the third right is the right against the co-sureties. So each surety will have a right against his or her co-sureties. So if one of the co-sureties is released by the creditor, he will have to make his contribution to the co-sureties. So if the co-surety, if the creditor says that we are discharging this person from being the surety to the agreement or to the contract, he will still have to make his contribution to the co-sureties, because in case of the principal debtors default, because the sureties had agreed to be sureties on the terms and conditions that there are other people also who are standing as a surety. So like we said, if I want to stand surety to my friend, if there is somebody else also who is willing to stand as surety, and if we are able to bear bear the loss in case if my friend is not able to make that payment. So 10 lakh surety, I'll say I'll pay 5 lakhs, and my co-surety will say that I'll pay 5 lakhs. Only then would I want to be a surety, because if I do not have the capacity of paying 10 lakhs, if my friend is defaulting, then I do not have the right to stand as a surety in this transaction. So if I have stood as a surety because there was a co-surety, then it becomes the co-surety's right also to discharge his liability towards me. And hence, even if the creditor is discharging the co-surety from, or releasing the co-surety from the transaction, he will still be liable to me as my co-surety and will have to contribute in case if the principal debtor does not contribute. So this is again an implied contract, even if it is not mentioned anywhere in return. It is an implied contract that the co-surety will have to contribute in this kind of a scenario or situation.
Ma'am, can you please explain right of security again?
Is it compulsory for existing debt? Is it compulsory for surety to come into picture at the time of formulation of the contract? Yes, even for existing debt and sometimes for future debt also, the surety will come into picture at the time of formulation of the contract only, because there's a possibility or there must be a requirement by the creditor that unless there is a surety, we will not enter into a contract with the principal debtor. So for that, this was a question asked by Anurag Ganguly. So for that, yes, it would be now compulsory or not. That would depend upon how the creditor will take it. Okay, but if the creditor says that he needs a surety, then the principal debtor will have to bring in a surety, and only then will the contract of guarantee start. Until there is a surety in a contract, unless there is no surety in a contract, there will be no contract of guarantee. Once there is a surety that steps in, then the contract of guarantee will commence from that point in time. Okay. So I hope that question is answered. Is there any question in the chat?
Ma'am, can you please explain right to security again?
Yeah, wait, I have listened to you. I've heard your question. I will explain that. I was just seeing if there are any more questions in the chat. Anurag, I hope I have explained that. In case if you still have any doubt on that, we can speak later on after the class.
It is clear.
It's clear. Thank you, Anurag. You were speaking about the right of security for the creditors. Okay. Now, what happens when the creditor gives debt to the principal debtor? What happens when creditor lends money to the principal debtor? When the creditor lends money to the principal debtor and the amounts are huge, then what happens? There are certain things which are kept as security with the creditors. Okay, the principal debtor may keep the documents of, if it's a vessel, documents of a vessel. If it's a house, document of the house. May keep some ornaments. May keep some fixed deposits. May keep some mutual funds, loans, shares, all of that as security with the creditor. Correct? Okay. Now, in that case, if the surety is making the payment, if the surety is making the payment to the creditor, what happens is creditor has got all his money now. Okay, so now the creditor will have nothing against the principal debtor. Correct?
Correct.
Yes.
Okay, the creditor will have nothing against the principal debtor. But who will have anything against the principal debtor now? The surety will have anything against the principal debtor, because he has paid the money that the principal debtor was supposed to pay to the creditor. Correct? Now his money is at stake. The surety's money is at stake. Correct? Because he's already paid the money to the creditor. Yes. Now what will happen to the surety? If the principal debtor does not pay him back the money, so in that case, whatever things were kept as security with the creditor will all have to be transferred to the surety. Got it?
Yes, ma'am.
Yes, ma'am.
With this, I think let us go on a 10 minutes break and come back
Ma'am.
at 11:45, and we will continue our conversation at 11:45. Yes?
Ma'am,
Yes, Ahmad?
in case of right against forced sureties,
Mhm.
you hear me, ma'am? Yeah, in case
Yes,
of
I
right
can.
against
Yes.
forced sureties, where we say that the release of the surety. So if there are two sureties and one of the sureties has agreed to be a surety because the other one is becoming a surety.
Correct.
If one of the surety is releasing itself, then will not the contract of guarantee be void because it was conditional contract?
He is not releasing, the creditor is releasing him from his liability. In that situation, the contract will not become void, but it will become voidable, not void. It will be a voidable contract in this situation. And if it is a void, even if it is a voidable contract, and if the surety, the other surety wants to go ahead with the contract, still the co-surety who has been released, his right, his liability to pay the contribution to the core surety will remain intact.
Okay, ma'am. Okay.
Yeah, it will be a voidable contract, certainly.
Okay, thank you, ma'am.
Okay. It will depend upon the core surety, that is, if A and B are the sureties to the contract, and if B is discharged by the creditor says that he doesn't need to be a surety in this. I want only A to be a surety. Then it could be a voidable contract where A can say that I would want to want to stay a
Does
surety.
really creditor have a say in that, because it's between principal debtor and the surety, that okay, if I cannot pay, this particular surety person will pay on behalf of me.
No, but
Creditors
the contract
usually...
is between the surety. No. The contract is between the creditor and the surety. The contract, there is a separate contract between the principal debtor and the surety, which, like I'm continuously saying, it's an implied contract, even if it is not in writing. But there is a contract between the definite contract, between expressed contract between the creditor and the surety. Okay. So yes. Yeah. So that contract will become a voidable contract if the creditor releases one of the sureties. The rest of the sureties will have the right to either avoid the contract or to go ahead with the contract. Even if they go ahead with the contract, the co-surety will still be liable to pay them.
Surety.
Okay.
Okay. Okay. Thank you.
Yeah. That we have completed our discussion on guarantee, and now we will start speaking about agency. Before we start speaking about agency, would any of you like to give any examples of any kind of guarantees that you all have seen in your, only if you are working for the shipping industry now? Okay. If any kind of guarantees that you have come across, or if you have worked on any kind of guarantee that was given for any of the transaction in your organization, or any of that, if anybody would want to share something.
A letter of indemnity provided by the charters to...
I cannot hear. Who's this?
Letter of indemnity provided by the charters to the owners.
Can you be a little more louder?
Hear me now?
Yes.
A letter of indemnity provided by the charters to the owners for carrying something which is out of the usual contractual agreement.
Wouldn't that be a contract of indemnity? I'm asking about a contract of guarantee. That is a very classic example of indemnity, which is a very good example, in fact, of indemnity. But about guarantee, if Anybody has any example? Anybody who's seen? Anybody who's been a part of any agreement where guarantee was given or?
Seaworthiness is a guarantee given by a ship owner to charter. That is one. Like
Seaworthiness is again more than a guarantee. It is indemnity given by the charterer.
Okay.
By the owner to the charterer. Sorry, it's an indemnity.
Ma'am, when vessel is in port and there is some urgent requirement to the vessel and the expenses are under head owner's account due to different time zone.
Yes. What did you say about vessel? Come again. Okay, anyways, let's move on to our discussion on agency now. Okay, and agency, I'm sure, yeah, somebody saying letter of credit, guarantee of payment to suppliers. Okay, Kamlesh.
Ma'am, I can give an example as you asked.
Yes, please, ma'am.
In my organization, we have a shipping management company. So one of the owner couldn't be able to pay the crew salary. So our management company has been behalf of them paying the salary, and they have been considered in some agreement with the owner stating that once you been the market booms up, you can pay us on later on. This can be as a surety. Like we have one of our owners, Core from Korea. They have a few tankers managed by our company where the owners couldn't be able to pay the money.
Okay.
So on that time, the management company has been indemnified and said, okay, we'll pay on behalf of you. And once you've been recover all the costs and all everything, so you can pay us back in that particular rate of interest or whatever it may be. So this was been discussed in a board of meeting. So this was when we comes across.
Okay. Yes. Yes.
Where the owner and all been agreed. Okay, the company will pay the management whatever the fees being paid to the crew and all. That will be in a written or a verbal. I don't have any idea basically, but I have been a part of that meeting. So it has been agreed and it has been solved later on.
Okay. 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 Anything else? Anybody? Otherwise, we'll move on to agency. Now, agency, before we start speaking about agency or before we dwell into the theory of agency, again, I would like the class to ask, not ask, rather to give me instances and examples of agency, agents in the shipping business or the shipping industry. What are the different types of agents in the shipping business? What are the different kind of roles that these shipping agents or any other agents who play a role?
And there are charterers agents, owners agents,
CHs,
agents, shippers agent.
freight forwarders.
Okay, so what is the role? What is the role of some of these? So what is the role of some of these?
Ma'am, CHs are the one who perform a custom clearance work, who enter customs and documents, filing and all.
One sec. Who's talking? Can I you know why? I don't know why I'm lighted here. I think I want to see the entire class on the screen, because then I will know who's talking. I'm not able to understand.
Ma'am, Akshit here.
1 minute. I think I need to do the gallery view. Sorry, I'm doing this. I have a speaker. Okay, sorry. I'm slightly technologically challenged, so it happens. Okay, somebody was giving me an example of.
Yes, ma'am. Akshit here. Ma'am, CHs are the one who perform our custom housing work. They file our documents, they clear our cargo and all. And ma'am, freight forwarders are the one who provide us freights and handle work on our behalf, like bookings and all, booking the vessels, hiring the containers.
on your, when you say your behalf, who are you?
We are the we are also the forwarders.
So you are also the forwarders. You are doing forwarding for whom?
In place of shipper.
You're doing forwarding in place of shipper. So if a
Yes,
shipper
ma'am.
wants to send his consignment, his container to the consignee, the shipper will approach you.
Yes, ma'am.
Correct, and you will do all the formalities
On behalf of him.
on behalf of the shipper.
Yes,
And
ma'am.
you also put the cargo or the consignment or the container, whatever you call it,
Yes, ma'am.
in the vessel, and then it will sail. Okay.
Yes, ma'am.
And then once it is sailed and once it has reached the port, who will handle?
Yes.
Who will handle
Their custom agents.
their custom
Their
agent?
forwarders are consignee for
So
consignee agents.
you are playing a role between the
Shipper and the consignee.
and the not the consignee, and the vessel owner or the charterer, correct?
Yes, ma'am.
You're playing a role over there in that. Okay. I see one more hand up, Manpreet Kaur. Yes, Manpreet.
Ma'am, one more example of agents.
I mean, if I can request, it's not a compulsion. If you can put your video on and if we can see you, just not a compulsion. If you're comfortable doing that.
Ma'am, one example of agents is that when our ships, like when the vessel is on the port, we coordinate with the agents for the other supplies that are need to be like provided to the ship. Which, like, suppose we've sent something from the office or something, so that we send it to the agents, and then the agents take it to the to the vessel, and then if any inspection is there, then the inspectors are to be taken with the help of agents or something like that.
What is your role? Who are you? In the sense, what is your organization? When I'm saying who are you, I'm asking what is your organization?
No, ma'am, we are ship managers.
You're a ship managers, okay?
Yes.
Okay. And so you are managing a particular ship. So you all have agents. And what business are you all in? You all are in cargo or
oil and chemical.
Okay. So you all have people who are sending, shippers who are sending their products or their goods or whatever, their oil through your vessel. Correct? Your vessel is transporting it from one port to another port. Correct?
Right.
If I'm understanding that correct. Okay. So now you are not the ones who are going to go and hunt for shippers. Probably it would be agents who you have appointed who's going to go and do all this activity. Correct. So there would be companies who would come and approach the agents, and these agents would then recommend that this is a ship line, cruise line or whatever, what you call a bunker, a tanker, whatever you call it. This is it, what is available, and there is space in this, and you can put your container in this, and it can be sailed. Correct? That is how it happens, is what you're trying to say, right?
Ma'am. Right.
Right? Yeah. Okay. So then this middle person who's acting in between, or who's coordinating rather with the shipper as well as you as a shipper manager, is the agent. Is the agent.
Yes. Yes.
Correct. Correct. That's what I'm trying to get these examples. I see a hand raised by Swapnil. Swapnil, you're on mute. 1 minute.
Yeah, can you hear me, ma'am?
Yes, I can.
Yeah. I mean, when it comes to my knowledge in terms of agency, like I'm working with a Parekh Marine Group. So like we have an agency of HMM and a couple of other shipping lines. So when it comes to us as an agency, like helping the shipping line vessel to clear the port clearance, MOD clearance, crew clearance, and all the basically being a mediator between the owners and their actual customers or the end customers, kind of. So as an agency, that's what the activity we do for
correct? You are an agent.
We are an agent.
Between the who is an intermediary or who is a contact point between the shipper and the shipping company. Correct?
Yeah, shipping company or even the other agencies involved, like the port agencies.
Okay.
Even the port agencies or the customs doing the MOD clearance like that. So that is one of the definition for us when it comes to the agency.
Correct. Correct.
That's
so yes. So yes. So when we are speaking about agencies, basically agents or these agencies are intermediaries who are, or mediators who are actually trying to make life simple for the shippers and also, for the shipping companies,
vessel owners,
who are the vessel owners. Yeah. So who are trying to, do all the job that a vessel owner would have perhaps done, or the shipper would have themselves perhaps done, to see to it that whatever the cargo is, it is getting sailed comfortably from one port to another.
I mean, we have local expertise which help owners to get jail with the particular
expertise are your representatives, correct?
Yeah, we are represented.
So the agency is your company. Agent is your company, and then you have your staff who is helping you do this. It is not a one-man thing. It is not like, somebody is selling bread. So I take it from I'm selling bread. I take it from the manufacturer and I go and, sell it, distribute it to the bakeries and all. So it would be a one-man show. But when
we have a skilled staff, basically. We have a skilled staff who are ex-merchant navy or who are some.
About a big business like a shipping business, then in that definitely it wouldn't be a one-man show. It would be a one company show, which is, dealing between so many people and handling so many things. Okay. So yes, so that is what basically agency is. Agency is an agent or an agency is there basically to support or to act on behalf of someone else. So when an agency is taking the cargo from the shippers, it is acting on behalf of the shipping company and taking the cargo from the shippers and loading it on to the vessel owned by the shipping company, and then the onward journey of the cargo begins. Okay. While doing that, the agency is also helping the shipping company to fulfill all the customs port related sort of formalities that are there. Sometimes the goods are kept in the warehouse, then transferring it from the warehouse to the vessel, and those are also some of the things that the agency may be looking at or taking into consideration. Correct. And lot of such other things is what the agency will be taking into consideration and helping. So basically it is the role of the agency to make life simpler for the shippers also, and for the shipping company or the charterer or whoever you actually name it or call it. Okay. So yes, that's what I wanted to understand from you about what is agency in shipping business. Because before we go into theory of agency, let us also understand. I thought it was good to understand or speak about. Understand is a lot of most of you all have the understanding about how agency works. So we spoke about different types of agents. First of all, in the shipping industry, and that is we spoke about freight forwarding agents, clearing and handling CHS, clearing and handling agents, correct? So can anybody quickly tell me what is the difference between CHAs and freight forwarding agents? Anybody who can tell me the difference between?
Ma'am, CHAs are mainly who become a mediator between a shipper and a customs, Indian customs.
Correct.
And a freight forwarder is someone who's more into the freight part. I mean, who's becoming a mediator between a shipper and the shipping line. They try to source the rate from the shipping line, the freight rates, and help shipper to get a better rates or to get a better solution. Right. Basically, they in a very short this.
Yes.
Freight forwarders are somebody who are like looking for owners or shipper to book a space or slot for themselves for their cargo on a shipping line.
This is Prabhakar. Prabhakar, can you please repeat it a little more louder?
Freight forwarders are basically someone who would be looking for booking the slots for shipper cargo on a shipping line.
Those are freight forwarders. And the CHAs are then, who are the CHAs?
they are basically looking after the custom part of the
clearing the goods.
export and import.
So also another question that I would like to ask you all is, could a CHA play a role of a freight forwarder also? Are there companies, organizations who are doing these multiple roles?
Yes.
Yes, ma'am.
Yes.
The clients that I deal with, exporters, clients that I deal with, most of the times we have a single agent who is
Yeah.
doing.
Yes. Yes.
Okay,
Yes,
who's
madam.
giving us the rate for freights, who's also clearing our goods, who's also trying to help us with all the custom formalities, right from we only have to send our goods to the warehouse, and right from there everything is handled by the CHAs and the freight forwarders. So it's just one party, one agent who is doing all of this for us. So that's also possible, right?
Yes.
Yes, madam.
That's possible.
Yes, ma'am, it's possible.
Who are doing all these roles also. So yes, again coming back to our point is commercial law, but how it is also applicable in shipping, because shipping is a commercial activity. Okay, and that's the reason why I wanted to bring out all these sort of types of any other types of shipping agents that we know of or that we should know of.
Madam, one stevedoring agency is also there, which plays a very important role when it comes to the ground level operations.
Yes.
So that is one agency.
And also there would be, agencies for towing your, towing, whatever, however you pronounce it, and, all those things. For that also there would be agents, correct? There would be different kind of people who would be dealing with all those kind of things. There would be agency for piloting.
Yeah. Yes.
There will be owner's protective agent also. So I don't know if Mr. Swapnil, what he said, I mean, CHS is the same one. He also takes care of the custom clearances and all. They are called owner's protective agents.
Protective agents. So you know what? Sometimes the role remains the same, but the designations, or people call themselves with fancy. Now it has become slightly a trend of a management also of giving. We have to look at the role. What I always feel is let us look at the role. What is the role that is played basically by these people, rather than going by what are the designations or what is it that they want to call themselves. I may want to call myself a queen, but I'm a lecturer sitting over here, correct? It is like that. So yes, what you're speaking, what you're saying, Jwalant is right. Those are also some kind of agents. So several kind of agencies. Yes, typically when we speak from the shipping industry, the shipping operations, these are some of the agents which play a very critical role. But beyond that, also there would be agents who are supplying some consumables to for the shipping industry, for your spare parts, for your repairs and maintenance, for the consumables that you require when the voyage is on. So food supply, and a lot of these things are there. So a lot of these kind of agents are there who will be involved in the day-to-day operations also of the shipping business and such kind of things. I can see a hand raised by Geeta. Geeta, is there anything that you wanted to share?
Yes, good afternoon, ma'am. I actually mentioned it in the chat box. This will be little, am I audible?
Yes, you're audible.
Yeah, this is a little different than our usual stevedoring, chartering, or even cargo booking. I belong to manning operations department, and we have manning agents when we have to employ foreign nationals on our ships. So those are the kind of agencies we do use. I mean, any kind of service that we provide to our owners will be through the agency.
So I have heard about this manning agency, and there was a discussion once we had when I was doing a lecture with IMEI, that is your Institute of Marine Engineers, when we were doing a lecture on principles of management, and I was calling them recruiters, and they were saying no, they're manning agents. So I was just trying to tell them simply that the role that they are playing is that of recruitment, right? Because they're employing foreign nationals. So yes, there are like we call like we say there are recruitment agents in the shipping industry. They are known as manning agents. I agree. So yes, they are also agents who are playing a role between the company and the prospective candidates. Okay, the company doesn't have to go hunting for these prospective candidates. It is the agents who help the company with finding these kind of candidates. Correct, Geeta? I'm right.
Absolutely.
Ma'am,
Absolutely.
in fact,
Thanks for hearing me out.
companies, they themselves, have a tagline, kind of, they are acting as an agent on behalf of the owners when we are dealing with the charterers or.
Yes, and that is true to not just shipping management company. Of course, this is a completely a concept from the hospitality industry on the whole, because many a times you see hotels also which are managed by companies. So there would be a brand, but that brand is only owning the hotels, but it is managed by a third party.
It's to limit your liability.
Yes, yes. A lot of times limit liabilities, or these companies, they have an expertise in that particular field. So the shipping management company, I would tomorrow want to, if I become filthy rich, I may want to start, a cruise line or something like that. But I do not really have the expertise in that field. So maybe I will start it on my brand, and then I would want a shipping company which has a good expertise in this, who would make my business really successful, to come and join hands and do that. So yes, shipping management. So and this is very 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 a lot of these hospitality concept I have heard. People having these kind of management companies, which actually the owners are separate and the management companies are separate. The entire bit of it. So yes. So
basically, anybody who's an intermediary between the two parties, like the owners or the charterers, anybody.
Yes.
So
yes.
they would be an agent. In husbandry, management, or custom.
Slightly louder, Prabhakar. Slightly louder.
It can be anything from husbandry to custom clearance. Since they are acting on behalf of the owner or the employer who has employed them, they would be an agent.
Yes, yes. Yes, so sort of, somebody has mentioned outsourcing. So sort of outsourcing. There are certain, sometimes, the owners will keep some role in their hands, and the shipping management company will have certain things in their hands. It could be a mix. It would depend upon from industry to industry. Of course, I'm not saying that is how it would happen, but it would all depend upon what kind of a agency contract. If there's a contract of agency, or if there is just another general contract between the companies, what kind of a contract would the companies want to actually enter into? Okay, so it would all depend. There is nothing stereotype. Stereotypes are only the practices from every industry. So you look at the best practices from the industry. Okay, so that company which is very successful indulges in this sort of practices. So let me also in my company have those practices. Okay, or this shipping company has this particular format of contract which has made them very successful. So let me also have that particular format of contract. So this is just benchmarking your activities or your practices with the best in the industry. Okay, but that does not mean that you are sort of compelled, or it is a mandatory thing for you to do that. Okay, you can have your own contracts with the agencies. You can have your own sort of set of rules and regulations for how you want to run an agency, or how you want to be associated with the principal, or whoever it is that you want to be associated. So overall, wanted to just have an overview of what are the different kind of agents who play an intermediary role in the shipping industry. So it becomes then a little more easier for us to understand the theory of agency, which we are now going to start. Okay, so let me allow me to share the screen, and can you all see it?
Yes, ma'am. Yes, ma'am.
Yes, ma'am.
Once again, don't get bogged down by the mention of sections, etc., etc. Okay, I have told you all this several times, and also, I just wanted to, I don't mean to be rude, honestly speaking, but I saw a question on what is voidable agreement in the chat box. Voidable agreement is something that we have spoken about ample times in the first few classes. If you are a new student who has joined after the first two lectures, you can please go back to the recordings and understand what it is, because some of these concepts, over and over again, if we keep talking about that, it will be a waste of time for us. Okay, so that's already spoken about in the previous classes. Okay, also about the sections, like I said, please don't get sort of surprised to see this section, because I had already mentioned that sections will not play a very important role when you're writing your answers. And particularly if I have to check your papers, I would never ever look at whether you have mentioned a section. And if I want you to mention a section, like I have said earlier, that the mention of the section will already be there in the question itself. Okay? So you can take a clue from that and write the section if you want to write. This is only for the sake of information and our learning. So Section 182 of the Indian Contract Act 1872 defines an agent as: an agent is a person employed to do any act for another or to represent another in dealing with a third person. So when we speak about CHS or your freight forwarding agents, it is the shipping company who employs these people and who will deal with the third person, that is the shippers. Correct me if I'm wrong. If you think that I have interpreted this definition, please write it in chat. I will look at your chats occasionally. But for my understanding, I think this is exactly how it works. You have these various agents that have been appointed by someone from the shipping industry. So for instance, there would also be, we spoke about agents like your pilot agency, or your towing agency, or your stevedore agency, and all of these. These agents are perhaps engaged by the port authorities. Correct? Am I right? They're engaged by the port authorities, and they play a role between the port authorities and the vessels. Okay. So basically, an agent is a person employed to do an act for another or to represent another in dealing with the third person. Okay. The person to whom such act is done is called a principal. So when we are speaking about CHAs and freight forwarding agents, who is the principal? The shipping company or the owners, or the, sometimes it could be the charterers also, who are given this, sort of responsibility of appointing agents and doing it. So then these people, they become a principal, and the freight and forwarding people, or the clearing company and all, they become the agents. Okay? Consideration is not necessary to create an agency. What does that mean? It means that when a company is appointing somebody or entering into a contract of agency with a freight forwarding agent, the company is not going to pay them immediately offhand. Correct? The company will give them commission for the work that they do, or whatever you call it. You may be calling it some other by some other name in your shipping parlance, but it that amount that is given on each transaction, that is the commission that is earned by the agency for doing that particular transaction, for getting that business to the company, and for smoothly then handling that particular transaction. So that is what agency is. Now here, when we are speaking about agencies, certain things maybe we can explain in terms of shipping, certain we will explain only in terms of, general explanation or general answers, general examples and all of that. Okay. So when we speak about modes of agency, how is agency created? Okay, so here you can see there are 4 different ways by which agency is created, and then there are 3 ways in number 2 how agency is created. And so let us see what exactly all these modes of creation of agency are. So the first mode, and which is the very obvious mode of creating an agency, is by expressed authority, given by spoken words or in writing. So, if there is a freight and forwarding agent, the freight and forwarding agent will not work just, for the heck of it for any company unless there is a contract between the company and the freight and forwarding agent. Okay, because the freight and forwarding agent, if he's not entered into a contract with the company, he may bring clients and he may do everything which he is not really even eligible to do unless there's a contract. And but in spite of which, if he tries to do it, he will not really get any commission, because the company will say, we have never engaged you to do this activity. Why are you even doing it? Okay, so in order to become an agent, there has to be something that is given in writing or also spoken in words. Okay, small agencies are not always given in writing, but that does not mean that if it is not given in writing, there is no agency. Now again, somebody who is trying to make a point that there was an agency will have to prove that yes, there was an agency. Or somebody who's trying to make a point that there was no agency will have to prove that there was no agency if it is only in words. And that is the reason why taking everything in writing becomes very, very critical in any commercial activity. Okay, faith, trust.
Ma'am, mode of creation of agency means the establishment of agency.
Give me a minute, please. Put your question in the chat box because it disturbs me otherwise. Or raise your hand and I will answer you. So I was speaking about expressed authority. Yeah, okay. So it loses my entire focus. So yes, I was talking about why agency has to be expressed specifically in and written specifically in a commercial transaction, because faith, trust, and all of this is all right till everything is hunky dory, everything is fine. But when things start going wrong, then all that faith, trust, and all, they just go down the drain. And then if things are not in writing, it becomes very, very difficult to prove that yes, that was it. There was an agency or there was no agency. Okay, that is the reason why it is very, very imperative, very, very important that things are in writing. Okay, so expressed authority is one way of creating an agency between the principal and the agent. Yes, Mr. Tiwari, what is it? What was your question?
Ma'am, creation of agency means the establishment of agency, or
yes, it means the establishment of agency.
Okay. Means whether there is agency or not.
Yes.
But why someone need to prove that there is some agency or not? They can simply ask the certificate of agency.
Simply ask the
certificate or the documents.
I hope you have heard what I have said. An expressed authority or an expressed agency can be in words also. I hope you are taking this conversation that seriously to understand when I am laying emphasis on this several times. That
what is the meaning of by words also? If there is agency, what is the
okay? So
by spoken word?
Allow me to speak then, Mr. Tiwari. Please allow me to speak now. I have understood your question. Let me speak. And I have been saying this continuously, that for a contract to be a contract, it is not compulsory that it has to be in writing. A contract can also be an oral contract. Somebody can
yes,
orally that you can be an agent and you can work as an agent with me. So when somebody is speaking orally that you can be an agent with me, where is the question of a certificate being in place? And we are speaking about creation of agency.
Because
unless the agency is created, where is the question of certificate coming into picture? How would a question of certificate come into picture? First of all, let us create the agency, Mr. Tiwari. After that, we will go ahead.
No, ma'am, if someone is saying that you are my agent, but the authorities, how authorities will allow anyone by if third party saying that he is my agent, how the authorities will allow that person?
So here we are not only speaking about commercial law is not only for shipping a business, okay, first and the foremost. So here when we are speaking about theory, we are speaking about the law of agency in general. So tomorrow, if there is a distributor or an agent who's taking bread from a general store to the shops to distribute it, there is not going to be any written agreement between the two of them that, you know, I am giving you 50 breads every day and you have to go and you know, sell it or distribute it to the to so and so society. Okay, it can be just be spoken. So you understand that when we are speaking about modes of creation of agency, it is not only for your shipping business, but it is for multiple commercial transactions that are there or that come into picture in day-to-day life of business.
Okay.
Let me move ahead now, because otherwise we are just wasting time on very not important issues over here. So by express authority is one way of creating of agency. That is, as we said, it could be spoken or written, but expressed in so many words. That yes, clearly mentioning that you're my agent, I'm the principal, I am giving you this responsibility, you have to play this role, and you have to do this as your duty as an agent. Okay, that is known as agency, which is an expressed agency. Okay, now there is an agency or authority that is given by under an agency, which is an implied agency or an implied authority. Okay, now this implied authority will be based on the conduct of the person. It would be based on the situation that has arisen. It would be based on the relationship, or it could be based on the circumstances. Okay, before speaking about A and B, I will speak about C first. Necessity, which is an example which would be relevant to the shipping business. Okay, so when we are speaking about agency, implied agency by necessity, typically what happens is when the vessel is sailing, is on a voyage, you know, and is at high sea, there's a possibility that any unforeseen incident can happen. Correct? There could be, you know, breakdown of machinery, engines, etc. You know, whereby it's not possible for the ship to continue its voyage. There could be accident. There could be a lot of other things that can happen. And in this kind of situation, the owners of the vessels are many miles, kilometers away from where the vessel actually is. Now, who is in charge of the vessel at that particular point of time? The master of the vessel, that's what you'll call it. The captain of the ship, the person who is, you know, in charge of all the activities and operations of that ship, is the person who is who's handling and who has to take certain decisions with regards to the ship. It may not become possible for this person to connect with the owners and get their approval for doing certain things that are necessary to be done for the ship or the vessel at that particular point in time. So he has to take certain decisions on his own. So he takes certain decisions of, you know, perhaps contacting the nearby ports, or perhaps contacting, you know, the nearby vessels that are available and asking for help, and getting certain things repaired, rectified, you know, certain machinery overhauled, certain things replaced, and so that the voyage continues and there is a smooth thing of voyage, you know. And in that particular scenario, there's a possibility that the master of the ship would also not be carrying that kind of money, correct, with him. So there's a possibility that he may want to keep certain cargo as security with the people who have helped them in restoring things that were necessary for the voyage ahead, and all of that. So the master has acted out of necessity and out of his relationship with the owners of the company. Okay, So there is an agency that is created. And in this kind of an agency, the principal, who's the principal over here? That's the principal is the owner of the ship, or the principal is the shipping management company or the charterer, whoever is actually who has employed this master and who has engaged this voyage will be in the capacity or hold the position of the principal. Okay, so here the principal will have to accept the agency of this master of the ship by virtue of the relationship, by virtue of the situation that has arisen, or by the virtue of the circumstances that has arisen in that particular thing. Okay, so this is what is known as an implied agency that is created in that particular situation. Yes, I know, I understand. Master will be an employee of the owner, right? Yes, master will be an employee of the owner, correct? Yes.
So, ma'am, in this implied authority, how are we saying that master relationship can be like an agent to the owner?
Can you be louder? Can you be louder? Please, I cannot hear you.
In this implied authority, how can we say that master can be in certain situations can be an agent for the owners?
That is the it is the sort of agency that gets created. Okay, it is not an expressed agency that happens, but he will act on behalf of the master is acting on behalf of the ship owner or the ship management company, whoever has engaged him in this voyage. Correct?
Yes, yes.
He's acting on behalf of this person. Okay, he is not doing something of his own accord, but he is acting on behalf of this person. So when tomorrow, when the time will come to pay those people who have done anything, that is, they have people who have probably repaired his engine, or people who have helped him in doing any other kind of, bringing in spare parts and all that. The master is not going to pay from his pocket. Will the master pay from his pocket?
No.
No, it is the person who has engaged him as an employee or as a master on that voyage will pay, correct?
Yeah.
So this person who has engaged him becomes the principal in this, and he will have to ratify the act of the agent. He will have to ratify the act of the agent. What is ratifying the act of the agent? That is also something that we will see, how an agency is created. So in this case, there is agency by necessity, okay, where the master has assumed the responsibility of the owner. If the owner had done exactly what the owner would have perhaps done in that situation, that is repairing the whatever the parts of the machine, parts of the engines, or the parts of the of the ship that were supposed to be repaired. So he's doing that out of necessity, because he's holding a relationship with the employer as an employee, and he's the one who is in charge of this entire ship. Without him taking this decision, the ship cannot move further. And because he's done this, now the principal will have to ratify his act, because if the principal does not ratify his act, then the employee, that is the master of the ship, will become liable to pay the amount. And why would the master of the ship pay the amount? Unless it is the fault of the master, and unless it is proven that the master has played some foul, but that becomes a different case altogether. Then that becomes a civil case, which is which can be fought completely otherwise. But if it was a genuine case, then an agency is created that way. How it will impact the relationship between how it will create a relationship of a principal and the agent, between the employer and the employee. And this is not true only in the case of shipping industry. It is also true in all other cases, also in business. In all other case of your employer and employee, because of your relationship, you are holding certain responsibility as an agent. If you are an employee of the company, you hold that agencyship of the company, and your employer becomes the principal and you become the agent of that company when you're dealing with the outside world. You're holding that particular, yes, Mr. Vinod Kumar, raised hand. Yes, Mr. Vinod Kumar, did you raise your hand? Do you want to ask anything? Or your question is answered already? So yes, like someone clearly said, that unless there is a contract, unless there is a letter, in particularly in your shipping industry, the port authorities are not going to accept a person as an agent. All that is absolutely true. Okay, but if you look at outside, so those are the norms of your particular industry, and particularly when you're speaking about maybe about the freight and forwarding agents or CHAs and all that. When you're speaking about them, that could perhaps be the case. But for some other agreements, for some other agency agreements, like your supply of materials or supply of your uh, uh, stationery in the office and all of that, you may not really require a letter from anybody saying that this is my agent and he will come and supply to you or anything like that. Okay, so there is something that you are taking, some stationery that you're taking from, you're buying from a particular brand, and that particular brand has told you that this particular person is our agent, and you can continue to buy goods from that particular person, buy your stationery from that particular person. Okay, now so you are in the practice or habit of buying. That person comes to you, asks for your requirement in your office, what is the stationery that you require, and you give him your requirement, and you are he is giving you this, and you're giving your payment to that person. Okay, after a while the agent the brand has terminated their agency with this person, but that brand has not come and informed you that the agency was terminated by them. Okay, you are still under the impression that this person is the valid or qualified agent, more than valid, qualified agent of this particular brand, because you were not informed that that agency is terminated, and you continue to buy from this person. Okay, you have also given him money advance because he asked for advance and he wanted some as you want some stationery from him. Okay? Now the brand will become liable to send you those goods because the brand had not come and informed you. That becomes your agency by holding out, or even to some extent um, agency by. Now when you speak about agency by estoppel comes from the word stop. Nobody has told you that the agency was stopped or terminated between the two parties, and that's how it will continue. So these are some of the forms how implied agency will be created, although um, uh, there may not be written. And the principle, why are we speaking about implied agency, is because looking at what is the role that the agent has played, whether it is the principal should be ratifying that particular act of the agent or not ratifying that particular act of the agent. That is something that can be decided. If the brand, like I said, has not informed you that this guy is not our agent anymore, and please stop buying goods from this guy. If they had not informed you, then they have to ratify this transaction between you and the agent. If they had informed you that he's not our agent and still you continue buying from him, then it is the company's fault, not the fault of the brand. And in that situation, the brand will not be liable to ratify that action. Okay, that is what is your expressed authority and implied authority and ratification by which agency is created. And last but not the least, by operation of law, that is every partner in the firm is an agent of the other partner. He's the partner He's the agent of the partnership firm and he's the agent of every partner. So in a partnership firm, it is a relationship of an agent. So everybody is liable to the other person's act. Okay.
Ma'am, explain this fourth point by operation of law. Again, please.
Law is, yeah, the operation of law is in particularly for partnership firms. In a partnership firm, where there's a partnership firm. So see, there are various forms of companies, correct? There is a sole proprietary firm, there is a partnership firm, there is a private limited company, there's a public limited company, there's a charitable trust, there's a cooperative society, correct? These are all various forms of companies. Perhaps you all have learned this in some of your other subjects. I have no idea. But so these are all various kinds of companies. When you want to start your business, you will start your business as one of these forms. Okay. You can be a sole proprietor where you are a single person handling the entire thing and you will just engage employees under you and they will take care. Or you enter into a business with a partner. Okay. So you and your partner, you associate together and you all want to do a particular business. So when you all are associating yourselves together and want to enter into a business, what happens is you are an agent of each other. So for whatever act you're doing, if you're doing a particular act on behalf of your partner will be the principal and you will be an agent. If your partner is doing any act on behalf of you, then you are the principal and your partner is an agent. So automatically there is a partnership created. And for any act that is done by any partner in the partnership firm, the other partners will have to ratify his action. Of course, if the act is done out of what is mentioned in your partnership agreement, if the act is done to deceive, to cheat, with fraudulent intention, then the partners will not ratify it, but that will need to be proved before not ratifying the act. Okay, otherwise the partners will become liable to ratify the act of the other partners, and that's the reason why it is said by operation of law, that is automatically when a partnership firm is formed, it is a law, clearly a law that one partner will be the agent of the other partner. Clear?
Yes, ma'am.
So the duties of the agents, what are the duties of the agent? The duties of the agent is to follow the directions of the principals. Whatever the principal says, whatever the principal wants the agent to do, the agent should do that. Okay, because it is ultimately the principal's business, and the agent has to abide by the directions of the principals to do that particular act. Okay, so it is the duty of the agent to follow the directions of the principals. It is the duty to follow customs in the absence of instructions. So it is not that the principal will constantly keep giving instructions to the agent. Okay, when the freight forwarding agent and the shipping company enter into contract, the shipping company will just give a broad perspective about how they operate. Okay, but it will be left to the prudence of the freight forwarding agent to decide how he should conduct himself as the agent. Okay, what are the customs that are generally followed while doing a particular activity? That is something that the agent will have to take into consideration and do. Okay, the agent cannot say, but the principal had not told me that we should do it in this way. Okay. If there is a particular way of doing it, which has become a custom in that particular industry, then that is how it needs to be done. Okay. The agent, it's the duty of the agent to take reasonable care and skill while doing or accomplishing any task on behalf of the principal. It is also a duty to avoid conflict of interest, doing similar things for different people. Uh, of course, when we are speaking about the freight and forwarding agents, they must be acting on behalf of 2 companies, 3 companies, 4 companies, correct? They would be acting because a freight and forwarding agent cannot just may not be it would perhaps not be feasible for the freight and forwarding agent to act only as an agent for one shipping company. Does it happen like that? I would like to hear from you all. People from freight and
No, ma'am.
people from freight and forwarding business. I would like to hear from you all. Do you all have only one company as your client, or you all have multiple companies as your client? Multiple.
Multiple companies.
Yes. You all will have multiple companies as your clients.
Yes.
So when you all are having multiple companies as your client, it will still be your duty to see that the interest of one company is not affected because of what you are doing. Okay. So maybe while giving the price to quotation to from of one company or of the other company, you shouldn't play. It will be your duty to not play against the other company. It is your duty to protect the interest of all the companies. Of course, in that it will clearly depend upon the shipper, what they want to do, how they want to do, because when I have exporters as my client, I've seen the shipper's side very closely, because I have exporters as my clients. I have not really seen the forwarding agents or the CH agents side that clearly. I know them as a client of my clients. So the shipper would be more interested in good rate. So the route, how it is, where it is, how it is going to go by, the number of days that it is going to take, and what are the storage conditions. Okay, because some of my clients are pharmaceutical companies and all of that. So storage conditions for their drugs, and these are some of the things that the shipper would definitely be interested in. So protecting the interest of the shipper is also of prime importance, and therefore the agent can indulge in suggesting that yes, this company would be better over that company for your particular kind of voyage. But the agent should not play against, should not try to bringing in a competition between the 2 companies or so on. Or the agent should not create his own other sort of shipping line and try to pull all the business of one particular company to on his for his own business or something like that. Okay. It is also a duty of an agent to not make secret profit. Okay. The agent has to be very transparently, the agent has to very transparently let the principal know what is the kind of profit that agent is making. Now, in certain situations, that may not really be a clause. It could be at the discretion of the agent to decide what is the kind of profit that they want to make. But where it is mandatory for the agent to disclose to the principal the profit that he's making, then he should be saying that he should be disclosing that to the principal. Duty to remit sums. If the agent is collecting money on behalf of the principal, then it is the duty of the agent to pay back that money that the agent has collected on behalf of the principal. Now, see, some of these things may or may not be true for your shipping industry. Okay, some of these things may not fall for all sort of agencies under your shipping industry, but they may be true for certain transactions or certain forms of agency in the shipping industry also. It is the duty of the agent to maintain accounts. It is the duty of the agent not to delegate. So if an agent if a principal or if a shipping company has appointed somebody as a freight forwarding agent, now he should not delegate the tasks related to this company to some other freight forwarding agent unless there is an agreement between the principal and the agent to do so. Okay? Otherwise, he should typically not indulge in derogation. Duty not to set up adverse title. Duty not to claim that these goods, like I was talking about, simple example, your office may need stationery, and the agent is, buying, the agent is taking stationery from a particular brand and coming and selling it to you. Um, the agent has to pay for the stationery that he's buying from that particular, taking from that particular brand. The agent should not say that this this stationery belongs to me, or I am the owner of the stationery. Okay, so that is something that the agent has to keep in mind and not do. And duty not to use information gathered in the course of agency against the principal. Okay, so when you're dealing with multiple shipping companies, you should not share information of one company, and very critical, crucial information that you have gathered in course of your relationship as an agent. You should not share it with the other company. So that is the duty of agents, and a lot of you are sitting in this room are representative of agents, and that is why it becomes very critical for you to understand that these are the duties, and if these duties are not adhered to, there is a possibility that there would be a liability that you will have to face. It could be any liability, like there would be a legal, a litigation that would be made against you. There would be a suit that would be filed against you in the court, and so on. You would be able to, you would be liable to pay some penalty for doing so.
Excuse me, ma'am, can you please explain the point number 5 and 6 again, please? Duty not to make secret profit, duty to remit sums.
There are a lot of questions in the chat, which I will try to answer a little later. We are already short of time. Okay, yes. Somebody wanted me to explain duty not to make secret profit. That is, whatever money the agent is earning from his transaction with the third party, if there is a contract between the principal and the agent, that he should disclose what is it that he's earned from the third party. The agent will have to disclose that amount to the principal and not make any profit secretly. So that is not actually tell the not tell the principal that I have only earned rupees 10, when he's actually earned rupees 12 from the third party. Okay, and duty to remit sum is sometimes the agent collects money on behalf of the agent. So again, I will give you this very simple example of stationery that I've taken, for which you have agents in your organization who come and deliver those stationeries to you as agents. If these agents are collecting money from you on behalf of the brand, they have to give the money to the brand, and then they will get their commission from the brand for selling of these or delivering these things to your office. Okay.
Thank you, ma'am.
Rights of an agent. That is the last topic for today, and then let us see what, if I have time, we will speak about about whatever has come in the chat, because there are too many, or I can address those separately also, if you all can write to me on that. Okay, rights of an agent. So there are 5 rights that we are seeing over here of an agent. There is a right to remuneration, right to retain, right to lien, right to indemnity, and right to compensation. Now, when we speak about remuneration, very often it is the commission that has been, agreed between the principal and the agent. Okay. Again, a question to you, freight forwarders or CHAs. What are the terms and conditions on which you actually deal with the shipping companies? What are the terms and conditions? I think people are now becoming very tired of listening to this conversation and perhaps want to take a break, but we will be taking a break. Yes. So my question is, on what terms and conditions? That is, you all would also be working for the shipping company for commission. That is, the shipping company would be giving you certain commission for every transaction or every consignment that you get for the shipping company or something like that. Most of the times it would be on the basis of that, right? Most of the times it is on the basis of commission that an agent works. Okay, so that commission becomes a remuneration. That commission becomes a remuneration for the agent, and it is the right to get that commission as a remuneration. Okay, if he's bringing in business for you, if a freight forwarding person or if a CHA is getting in business for you for the shipping company, you have to pay him his commission, right? It's his right to get that money. Okay, so it's a very, very simple right, and it's a very fundamental right of a person to get that money from the person. Okay, so that is the right to remuneration. What is the next right we spoke about? Right to retain. The agent is possessed of a right to retain the money of his principal unless his claim from the principal is fulfilled. So, if the agent is collecting money on behalf of the principal, if the agent is collecting money, that is, if the shipper is paying the money to the freight forwarding agent, or the shipper is paying the money to the clearing agent, okay, which actually who is doing the voyage? The voyage is that of the ship owner, right? It is the shipping company who needs to get that amount, because the shipping company is the one who's actually transporting the cargo from one port to another port. Okay, in that case, if the agent is not going to get his remuneration, then the agent will have the right to keep the money with him unless he's getting his remuneration. Okay, first time maybe you send the money, you have not got your commission. Second time also maybe you will give the money that you have received on behalf of the principal, that is shipping company, for example. But still you're not getting your commission. How often are you going to just let your commission go? So you will have the right to retain the amount that has come to you on behalf of the principal, that is the shipping company. Okay, right of lien. Besides the right of retainership discussed above, the agent will also have the right to retain the goods, papers of his principal, whether movable or immovable, which were received by him in the course of business until the amount is due from him from the principal in the form of commission. So whatever things he has, the agent has received, the agent can also create a lien on the cargo. The cargo is not basically, the cargo is not of the shipping company. It is that of the shipper basically. But whatever that he will have, in his hands to create a lien on, because he is also working. It's his hard-earned money, and he also needs that money. He needs that remuneration. He needs that commission. And if that commission is not going to come to him, how is he going to survive? He also has got, like when we spoke initially, we said that for a freight forwarder or a clearing agent, it is not just him, it is his fleet of employees that are working along with him also, whose salaries he has to pay. It is a warehouse that perhaps he has taken, and he's paying for that warehouse space where the consignor is coming and dumping his goods to be taken into the cargo. So there's a lot of cost involved for the agent also. And if he's not going to get his commission, either from and the payment is something that will come, that may be coming. How does the payment come? Does the commission only come from the shipper, or does the freight forwarding and the clearing agent also get some money from the shippers? Is it only the shipping company who pays them, or it's also the shippers who pay them? Quickly.
Owners pay.
Okay. And the shippers?
Charterers also.
Yeah, owners, charterers, I'll put them in one category. These are the people who are actually responsible for the voyage. Correct? So I will put them all into one category. what happens with the shippers?
Shippers also do pay, ma'am.
Shippers will also have to pay. No, why would somebody do a free job for anybody?
The classic example of if it is the BL charges, DO charges, THC, and the charges that agents collect from the shipper.
Yes.
And a very simple day-to-day example of the charges they collect from the shipper.
Yes. So in this particular situation, it is also the agent is acting on behalf of the shippers also. So the agent, so here the agent, the shipper will become a principal, and the agent will become, the agent is the agent itself. Okay. So if they are not getting money from the shipper, they will have the right to claim a lien on the cargo that they have collected from the shipper. Correct. They will say that why should we give your cargo if you're not going to pay us? Pay us our dues and take your cargo. Okay, that is also something. So that is the right of lien. Lien, basically, when you speak of lien, it is creating a charge on somebody's goods. Okay.
They can hold the PL of the shipper, bill of lading of the shipper, if they don't get the charges.
Bill of lading of the shipper.
Yeah.
Then bill of lading, and then there is a lot of procedure and lot of conversation that we can have on that entire bill of lading. Which is a very, very critical thing in your shipping. It's a Bible for your shipping business, actually.
Yeah.
Or a Gita or a Quran, you can say. Based on that, everything, the certificate of birth and certificate of death, basically. So that's how important it is. Anyways, let's not get into that conversation. But correct. So all of this. So right of lien is also something that is entirely important or very important in case of for the agent. If he is not going to get his compensation, if he is not going to get his remuneration, he has the right to do that. And if he does that, and if somebody sues him for doing that, the court will first ask, why did he do that? And if he says that I did it because I was not getting my remuneration on time, I was not getting the dues that I was supposed to get, then the court can decide the matter in favor of him. So that's what we need to understand. Right to indemnity. Okay, right to indemnity is that the shipping company or the people who are responsible for the voyage will have to indemnify the agent because he is responsible for the shipper's goods. They will have to indemnify about the safe voyage, about the seaworthiness, about all of these things. That is the kind of indemnity that they will have to give. And on the other hand, the shipper will also have to give indemnity to the agent, saying that the goods are not of hazardous types, and it will not really create any problem for the other goods. It is not that hazardous goods are not carried by cargo. Hazardous goods are also allowed to be carried by cargo. You all would know it better than me, but there are certain rules and regulations. There are certain sort of declarations that needs to be made if hazardous goods are being carried on a board. Correct me if I'm wrong. So the hazardous goods are carried, but then if somebody is sending hazardous goods, they will have to indemnify the agent that these are hazardous goods. They need to be carried in particular manner. So we need to have a vessel which can take care of these hazardous goods to be carried. Okay, so that is the right of indemnity that the agent will have against both the principal and the shipper. And last but not the least is right to compensation. Right to compensation is, we have missed on one point, and I would please request you all to keep in mind. I think we have to talk about the termination of agency, but it's all, I don't want to stretch, I don't want to just hurry up. Next time we will start with the termination of agency and then move on to bailment and all, and we will be a little more faster next, because now I think you all have started getting the hang of what are special contracts and what typically happens in all these kind of special contracts when it comes to the shipping business. Okay, so the last is right to compensation, and right to compensation is basically again remuneration, and if remuneration is not paid on time, then damages also, interest on that remuneration, damages to be paid on that remuneration is also something that is the right of the agent. all those who have questions can please, I forgot my number. Yeah. Can send me a WhatsApp on this number because this chat will go and I have to stop the class now. So whatever questions you'll had, please send me a WhatsApp on this number. I will answer your questions. With, let me have a look. Slide again. What is left? Yes, termination of agency is left, and then we have to start with bailment. So please remind me. I'm also making a note of what is left now. Today's date is 5th September. Stop at rights of agent to start from termination of agency. Okay? Can we close the class?
Yes.
Yes, ma'am.
Yes, ma'am.
Yes, let me handle
Ma'am, where to locate? Where to locate your number, ma'am, which you provided? Where to locate it?
Where to locate? This is on. See you on the 19th. Thankfully, there's not much of gap between the two classes. So we will be able to continue our discussion. Just that we'll have to be a little more faster.
Thank you, ma'am. Wish you happy Teachers' Day once again.
So much, everyone. Thank you.
Thank you, ma'am.
Thank you, ma'am.
Thank you.